You have an estate plan in place, but you've been told that maybe your family will still have to go through the probate process. Why is that? Let's talk about it. First, let's start with what kind of estate plan do you have in place? If you have just a power of attorney, for example, that terminates upon your death, and that is not a document that will transfer property. So we take that off the list. If you have just a will, if your estate plan is a will only and nothing else, have in mind that a will is just a wish list for the courts to administer. So a will requires probate if needed. If, for example, you have real property, that triggers probate. Another thing that triggers probate is financial accounts without beneficiaries. So if you have a life insurance policy, if you have bank accounts, retirement, without listed beneficiaries or with beneficiaries who have predeceased you, then your family may have to go through the probate process, and through the probate process, the will be used. We have lots of videos on why a will has to be probated, so I'm going to move on to the next section, but be sure to watch our other educational videos on that will only topic. The third one is beneficiaries. As I just said, if, for example, let's say you have a life insurance policy of $75,000 and you have your spouse listed as a beneficiary and nothing else, and both you and your spouse pass or your spouse predeceases and you never updated the beneficiary form, then you'll have no beneficiaries. The life insurance company is not going to know who to pay. They're not going to say, oh, how many kids do they have? Were they married? They're going to say, you file for probate and I'll give that money to the estate, to the court system to figure out who gets what. So that's when your will, even your trust, may have to be used and follow those wishes, but still a financial account without beneficiary may trigger probate if it's not set up properly, either by having primary and secondary beneficiaries listed or by having that financial account owned by the trust if you have one. We've talked about a little bit about trust. A revocable trust can help your family avoid probate, but if you have a trust and you don't have all your assets included in the trust, then those accounts or real property may have to be probated. What does that mean? Let's say you got a trust created a few years ago and the attorney who helped you with the trust placed your residence into the trust, so that's taken care of. And you do that through a deed that gets recorded in a land record. But let's say in the meantime you bought another house or the neighbor's land, or you inherited some real property and it never got placed in the trust. Well, that property will likely have to be probated. So in order for a trust to work, it has to have things in it, and the way you put real property in it is through a deed. So if you're not sure what that means, but you know that you have bought or inherited property since you had the trust created, I recommend that you look into it. As a quick recap, yes, you can still have an estate plan in place already and still put your family through the court system for the reasons we talked about. So be sure to give us a call, 405-857-8231, if you are ready to talk about your estate plan, or if you want a second pair of eyes to review your older documents. We're here to help. Thank you for watching, and be sure to subscribe to our YouTube channel through that red button there at the bottom. Thank you.